Good afternoon, everyone. This is our fourth session of Washington Arbitration Week's fourth day in 2021. This is our second edition of Washington Arbitration Week. And today we have an incredible panel which relates to matchmaking. I will not further disclose the topic of our panel, but all of you, I believe, know that it's related to third-party funding in international commercial arbitration. I will let our incredible moderator, Michael Kelly, introduce the main theme of our last session of today's. And I will, however, introduce Michael as our moderator. Michael has more than 25 years of experience assisting U.S. and international companies and funds with all their investment needs. He represents both inbound and outbound investors on the structuring, documentation, insurance, and management of investment funds, including providing counsel on regulatory compliance and best practices. He is experienced across the broad range of asset classes, including private equity, venture capital, and blockchain. He is a former general counsel of EMP Global, where he oversaw approximately $8 billion in assets across 10 different investment funds in emerging markets. He has served on investment committees and advisory boards for funds, and as well as broad board of directors for project companies in Latin America, the US, Canada, Asia, and the Middle East. He has supplemented his investment funds work as a transaction attorney and thought leader in the realm of litigation finance. He advises on the structuring and documentation of litigation finance transactions between and among funders, claimants, and law firms. He's also a frequent speaker at litigation finance conferences, such as this. Michael also has significant experience with social impact investment funds, including creating innovative structures for blending for-profit and non-profit capital. He also provides general corporate counsel, and he has served as an arbitrator and mediator in complex financial and trade disputes at the American Arbitration Association and the International Center for Dispute Resolution. He is, of course, the founding partner of Parker Poe, attorneys at Counselors at Law. One specific detail that I would like to share about Michael is that he is incredibly generous with his advice and always thinking in terms of how you can move some financial needs of clients. And that's how I was pretty much introduced to him, and then we have been in contact ever since. And he has, I believe, also great characteristics to moderate this panel, because he knows quite a bit about litigation finance and counsel work, and how you could actually do a good matchmaking between client, a funder, and their counsel. Michael, the floor is yours.
Great. Thank you very much, Jose Antonio, for that very generous introduction. Much appreciated. Welcome to everyone to our panel today. This is an exciting time for all of us in this industry, and we're certainly happy to share with you all of our knowledge and experience here in terms of third-party finance in the international arbitration context. Without further ado, our panel title is called Matchmaking: How to Find Your Third-Party Funder in International Commercial Arbitration, Third-Party Funding Across Industries, Types of Funders, Big and Small Claims, and Means to Fund Them. I'm joined today on this panel by some of the best practitioners in this industry. We first have Kirsty from Validity Finance, who's with us today. We have Stuart Akerley from Statera. We have Tim Feary, a practitioner in international arbitration from Aaron Fox. And we have Maria Lucia Casas from McStrategy, who has also been one of the organizers here for this fantastic Washington Arbitration Week. I'd like, if I can, before I make a few brief introductory comments to sort of set up our panel, I'd like for each of my panelists to take a minute to introduce themselves. Stuart, do you want to start off?
Sure. Thanks, Michael. Stuart Ackerley, director at Stater Capital, where I'm head of originations. I previously practiced at Williams & Connolly in Washington, D.C., where I focused on complex commercial litigation as well as international arbitration work. And then I took a slight detour into the government for a few years as Deputy Chief of Staff of the U.S. Trade Representative's Office, primarily focused on renegotiating NAFTA with the USMCA, and then also served as Chief of Staff at the U.S. International Development Finance Corporation, which is the government's $60 billion development bank. So really happy to be here. Thanks so much to the organizers for having us.
Great. Thank you very much, Stuart. Tim, how about you?
Hey, thanks very much, Michael, and thanks to Jose Antonio for inviting me to this, and then you as well, Michael. My name is Tim Feary. I'm a partner at Aaron Fox, and I head up our international arbitration and dispute resolution practice. I've been in Aaron Fox for about 7 years, I think, at this point, and before that, I was an appointee of President Obama at the chaired the U.S. Foreign Claims Settlement Commission, and before that, I was a State Department lawyer at the Office of Litigation and Investment Disputes. So I won't go any further and leave it there. Okay, thank you.
Great. Thank you very much, Tim. Maria Lucia, you want to say a few words?
Definitely. Thank you, Michael. Well, as you might tell, my name is Maria Lucia Casas. I'm a Colombian lawyer. I'm associate of arbitration and international law at a boutique law firm called Strategy LLP, with presence in Colombia, which I'm here, and Washington, D.C. At Strategy, we have acted as counsel in various investment arbitrations as well as commercial arbitrations. And since we have various experience with funding, we have been helping clients that are seeking funding to successfully obtain it. So that's why I'm here.
Great. Thank you, Maria Lucia. And last but not least, Dave Kirstein from Validity.
Thanks, Michael, and thanks, Jose Antonio, and everyone for having me here. Excited to be on this panel today. My name is Dave Kirstein, and I'm the Chief Risk Officer and one of the founders of Validity Finance. We're a commercial litigation finance company that's been open for just about 3.5 years now. But all of our management team has worked together in this industry for quite a while. Before coming over to help found Validity, I was an investment manager at Bentham, which is now Omni Bridgeway, for about 4 years. And before that, I was a commercial litigator, trial lawyer at Gibson Dunn in New York for about 15 years, with a focus on a number of things, one of which was international arbitration.
Great. Thank you very much, Dave. And again, thank you to all the panelists and to the organizers today of our conference in this panel. Just a few words before I jump into some of the specific panel topics here that I will be posing to the various participants. I think all of us on this panel and many of you in the audience have certainly seen the growth of the litigation finance industry as a whole. It seems particularly the last 2 years to 3 years, there's been enormous growth in terms of the amount of dollars that are flowing into the litigation finance industry, the variation, the type of cases and claims that are getting funded, and also the type of participants who are coming into the market. It used to be the case where we had to spend a lot of time sort of educating others about what litigation finance is and isn't. And I think we're clearly sort of moving beyond that. There's a broader knowledge base now about the industry and what litigation finance can do for all kind of claimants, whether they be individuals, small companies, large companies, as well as for law firms of all sizes, and everything from solo practitioners all the way up to the AmLaw 50 firms and everything in between. I was really fascinated by the title of this topic, matchmaking, because I think, sort of finding the dating game kind of analyses here or analogies. It really is important, in my view, for there to be a very good match between and among the funders, the attorneys representing the claimants, and the claimants themselves. And part of this is just structural issues, what kind of claims these funders will fund, what are their financial investment levels, but also more intangible things like temperament. And how will you get along for what will be a very long relationship among yourselves as you try to press your cases and claims, particularly in the international arbitration context. So I think this is a really timely panel. It's an important panel, and I think it's one that I know will be beneficial to you because every panelist here has just a remarkable depth and breadth of experience in this space. So without further ado, I'm going to jump into some of our first questions here. And Dave, I'm going to pose this first broad question to you. And of course, all other panelists feel free to jump in as you would like. So Dave, what factors have led to the growth of third-party funding international commercial arbitration in your view?
Sure, thanks, Michael. I think first of all, it's the ever-rising costs of bringing these kind of cases, of the lawyers' fees, of the experts, of the arbitrators themselves. And of course, the time it takes and the risks involved in expending so much on what is most likely an uncertain outcome when you first started. And so most parties or many parties don't want to or simply don't have the means to bear those expenses and risks themselves, no matter how valuable their claims might be. And while this is starting to change, many lawyers and firms still can't share that monetary risk with clients, or at least they can't share it as much as the client needs or wants them to. And so litigation finance companies are needed as a small p partner that can come in and help bear or share that risk. I also think sort of the growing use and acceptance and education over the past decade that you alluded to, Michael, really especially in the past 6 or 7 years, kind of feeds and builds on itself. And so it's no longer a novel thing to have litigation finance. It's become more commonplace, certainly in the international arbitration space and in the patent space specifically. And so that just kind of builds and feeds on itself. And so once the bar was educated, and there's been a lot of education by funders in the past decade, and international arbitration is probably one of the earliest adopters of funding. The fact that it can be so useful to lawyers and their clients made it, only natural that its use would increase.
Great, thank you, Dave. Maybe I might just want to add that it's always the interesting use of litigation finance as well can oftentimes be seen as sort of the David and Goliath stories, of course, because of sort of the financial imbalance oftentimes between claimants and the respondents. But we're increasingly seeing litigation finance being used by large corporate players who really can't afford to finance their own cases, but feel they might want to use third-party finance in order to sort of keep their dry powder for other purposes in the company in terms of developing their business and maybe expanding their footprint. So, it's not just the David and Goliath stories anymore, but there is a broad range of sophisticated claimants who are demanding increasingly, access to this kind of financing.
Yeah, and I would add, Michael, I've come across a very savvy claimant who got a claim funded, and then at a certain point in the life of the case, he sought third-party funding, and the reason for that was to basically hedge his risk at that point. And the money at that point also was cheaper because we had gone down the road a while. I thought that was certainly a first for me. But I thought it was, quite a rational action for him to take at that point in time.
Mm-hmm. No, that's a very good point, Tim. And what we oftentimes see in this industry is, and one of the product differentials is that some funders will only want to fund sort of very early cases in development. Others will want to come in a little more advanced as the cases have reached certain critical thresholds. Maybe they've gotten through sort of in kind of motions to dismiss or other type of preliminary proceedings. And then there are, of course, those funders who want to come in on the back end and help sort of monetize a judgment or to enforce a judgment. And so it's one of the interesting things in our space is that it's one of the inquiries I always receive from particularly the newer players is what niches in this industry have not really been well addressed yet. And we see all kind of new players who are looking to try to find out what those niches are and also kind of what aspect of the market is being sort of underserved. So it's also interesting to see that the claimants are sort of trying to take advantage of this kind of variety of types of funding as well. So, Dave, just to continue with you a little bit further here, in your experience, what makes international commercial arbitration an attractive part of the litigation funding asset class, looking at it from the perspective of the funders?
Sure. I mean, I think first of all, the amounts that are often at issue in these cases can be attractive to funders looking for significant returns on their invested capital. Second, for some what I'll call business to business commercial arbitrations to be distinguished from treaty arbitrations, the time to completion or resolution can be shorter or more certain, especially in the time of COVID now, with courts shutting down and backed up and travel restrictions that we're all familiar with. With an arbitration, of course, you can have important hearings by Zoom, don't necessarily have to travel, can move forward even when courts are shut down. And so you can get a little more certainty on the duration, which is always a big risk that funders are looking at. And third, there are less hurdles to get over to get to a hearing than there would be to get to a trial in a litigation where you have to worry about motions to dismiss and summary judgment motions that can knock you out of the box. You can have motions potentially to knock you out of the box in arbitrations, but it seems less likely. And then fourth, there's also something nice in some litigants, like maybe even comforting, about having a hand in who your trier of fact might be. Your ability to help select the panel is attractive.
Great. Well, no, thank you, Dave.
Michael, I would just point off what David was saying. I think all those things are exactly right, and a couple other things that we think about are the fact that in the commercial context, you're generally dealing with pretty sophisticated parties who are going to be rational actors. You're less likely to have binary outcomes. Settlements are more likely in the commercial arbitration context than in the investor state context. And tied to that are also just collectability and enforceability concerns, which also go to duration, like David mentioned, but you're less likely to have a second stage of litigation where you have to go enforce an award against a sovereign in the commercial arbitration context.
What about just related to this? What about sort of the imposition of adverse costs in sort of the international arbitration context? How much of a concern is that for the funders? Say Cetera or Validity, and so how are you mitigating against that risk?
I can go first. I mean, it's certainly an added risk that we look at very carefully. And, there are ways to mitigate against it, using insurance, perhaps, making sure that your counterparty as the funder, the claimant, is well capitalized enough to bear those potential costs if need be. We generally don't take and in fact disclaim any responsibility for those costs and try to make sure it's covered in other manners, because we don't want the added risk, unless we may perhaps help fund an insurance policy to make sure that those sorts of things are covered. So it's another moving part that does add some additional risk to these type of investments, in my view.
Sure.
So David, can I ask you a question? Let's assume there are adverse costs and they weren't included in the deal, the third-party funding deal.
Right.
Do you really care at that point?
The time I care most is if there's a chance that my company can get tagged for it. And there's some open question about that in some jurisdictions. There's been one or two, what I would say, bad decisions on this point by arbitration panels, or in the UK. Now, they're very distinguishable from most situations. Sort of the most famous one, and the name's escaping me right now, was held that a funder was liable for the adverse cost award where they hadn't done their own diligence and research and basically just took at face value whatever they were shoved in their face, and therefore sort of helped fund and proliferate a frivolous arbitration or litigation. Sorry, I was getting some feedback there. And then secondly, that the counterparty was impecunious and they knew that when they entered into it. So we don't usually fund into those sorts of situations, so it shouldn't be something that would cause us to get tagged with an adverse cost award. But you never know what a panel is going to do. You never know what a court in another jurisdiction might do, and so we're careful about that for those reasons.
And I think that's pretty consistent across the funding community. There is sort of specific disclaimers about being responsible for adverse costs. But where it seems that it's a critical part of the arbitration agreement, we're oftentimes seeing insurance products used to help mitigate that risk. Of course, that's added cost into the financing as well, but it adds that extra layer of protection for both the claimants and the funder. I'm going to pivot now a little bit, and Stuart, I'm going to turn this next question or two over to you. And this, now that we sort of talked about kind of where the growth is coming from and what are the attractive aspects of international arbitration for the funding class and for litigation funders, can you just walk us through the types of funders that are out there for clients and counsels, maybe addressing a little bit the size, industry focus, those kind of things, that kind of those practical sort of aspects that I think it's just important so that clients and lawyers don't kind of waste their time going, down the path of one funder versus another.
Sure, absolutely. Thanks, Michael. And we've already alluded to one of the characteristics parties should think about, which is just what stage are they at in the arbitration. And some funders like to come in early, some like to come in later. So there's a variety there. I think the first one I would start with is just size. You're going to find funders who have an appetite for a wide variety of sizes in terms of investment size. Some funders will be looking for cases of $5 or $10 million or greater for a single case. Others are going to have a lot more flexibility to go below that and down into the six figures, into the $1 to $5 million range. And those financing amounts can translate into cases with resolution values that are in the seven figures and up to the 8, 9 figure plus awards. And then, of course, some funders are more interested in financing portfolios rather than single cases. And so they'll finance a set of cases to cross-collateralize their investment. In addition to the size, there's also flexibility in what the funders can finance, whether it's attorney's fees, whether it's costs, experts, arbitration costs, or whether a client's looking for some working capital to help keep the lights on while they wait for the eventual award to come in and to collect on that. I'll just give by way of example, at Statera, we have a lot of flexibility in our investment size and structure. So we've financed an arbitration in the mid six figures, but have also done cases that are into the millions. And so it really just depends on what the funder is set up to do. I think one of the upshots of all of this is that, perhaps contrary to some common conceptions, an international arbitration doesn't have to be large or part of a portfolio to get funding. I think you see more and more funders willing to take a wider variety of cases. Second, in terms of industry focus, again, it really varies widely. You've got, I think, a lot of funders who are interested in general commercial type claims. International commercial arbitration, I think, is a great fit for those. A lot of them are often breach of contract cases that have foreign or exotic elements, but at their core come down to a few key documents and a few key contracts. But some funders might be more interested in intellectual property type disputes, or disputes that have a even more exotic flair that may involve issues of foreign law or regulations, or the investor state dispute type case, which I think we'll talk about a little bit later. Third, in terms of control and influence, from my experience, at least, funders will almost universally disclaim any control in the litigation. As I like to say, funder is not a front seat driver. We're not a back seat driver. We just have a ticket to the racetrack to watch it go by. The lawyers and the clients are in total control. And that's how it should be, frankly. And then finally, the last one I'll touch on is just disclosure. And that's a hot topic in the ICC's 2021 rules. They added a provision, Article 11.7, which requires disclosure of the existence and identity of a third-party funder. I think, from Statera's perspective, at least, we don't view disclosure as a bad thing as long as it's done correctly. I think there are some concerns, especially if defendants use disclosure to create expensive, distracting fights during an arbitration. That would be, I would equate more to what you see in U.S. courts in an international arbitration. But ultimately, disclosure helps legitimate third-party funding as a proper ethical part of international arbitration and as a way for litigants to have greater access to justice. And I think as courts and arbitral tribunals continue to overwhelmingly approve of litigation funding, as well as protect litigation funding documents and materials from disclosure, that there will be fewer of those types of discovery fights in the arbitration context.
I would like to, Michael, maybe I would like to compliment the Stuart from the client and of course the counsel's perspective. And since there is, of course, a wide variety of funders out there, some of the good practices and the tools that we use at Strategy when we are advising clients on how to find the adequate funding is that we have developed a database that includes around 60 or 70 institutional funders. And what we did is that we discriminate these funders in different points by key contact, by the industries and the type of fundings they fund, by the size of funding, the country or the countries in which the funder is based, and of course other key characteristics that will be useful in order to decide and to help client in order to determine which is the best suitable funder out there for a specific client. Because of course there is a wide variety of funders, but also as a remark, this does not mean that every case will be funded. For instance, this is the contrary because funders are used to very strict due diligence process. And I think that in practice, this have shown and this have been confirmed that from the cases that the funders actually study, less than 10 or 5% are matters that they actually decide to fund. So this is a very good practice that we have adopted Strategy. And I think that it's really useful for every law firm that advise clients on how to seek and of course, achieve funding.
Sure. Yeah, and we're going to be talking a little bit later in this panel about kind of how claimants and law firms, what are the sort of the tools and where you can go to sort of find information about funders in a more practical way so you can try to help identify the best fit. But just to add to what you were just saying, Maria Lucia, one thing I found really interesting about our industry is, of course, we have a very broad range of dedicated funders and have been doing this a really long time and are really good at it, such as Validity and Statera. But we also have new entrants, multi-strategy funds, larger investment banks, some family offices, even some high net worth individuals who will sometimes want to tag in or behind a funder to help fill a funding gap in a particular project. So there's a lot of variety in terms of the supply or potential source of supply of finance, and that certainly gives more optionality, I think, to claimants and to law firms to try to find the best fit. What about now the intangible aspects of sort of the funder law firm client relationship, sort of temperament, funder temperament, and sort of the bedside manner. Obviously, the process of negotiating and arriving at a funding agreement is an oppositional process. Everybody's the funders trying to get the best deal they can, the lawyers as well, and the claimants are doing their part to get their best part of the deal. But what about what happens next after the claim is funded? And these are long, particularly international arbitration cases can run for a long time. It seems to me that temperament and personality are also important. Would any of you want to tackle that question?
Sure, I can start, Michael. And I think you're absolutely right. I mean, these cases typically last for at least a couple of years. So when you enter into a funding agreement, it's a long-term relationship. I think one of the things to consider about temperament is what's going to be a funder's approach to monitoring your case after they've closed. I mean, every funder will track and monitor the cases they invest in to see how they're progressing. And I think some funders can take a higher touch approach to monitoring. Other funders can take a lower touch approach. And I think it's important just from an expectation standpoint to know what is the funder going to require from the lawyers, from the client on a monthly or quarterly or whatever basis it is, just so there aren't surprises down the road. And I think you can really just find, based on you and your client, some funders are going to be easier or more pleasant to work with than others. And that's just going to vary by funder. It's going to vary by client, of just who you get along with. who's got a personality that complements yours. And I think another important consideration, I think about this just from my time practicing, arbitration and litigation is inherently unpredictable. A funder is going to spend a lot of time doing their diligence and structuring everything in the best way possible. But no matter how much diligence you do and how much structuring you do, things are going to happen that you didn't anticipate. And so if you're a counterparty or a law firm, you want to know whether your funder, how are they going to react when those happen down the road? Are they going to be a creative problem solver that works with you to find mutually acceptable ways to address the problem? Are they going to try to pull the rug out from under you and invoke a provision of the funding agreement that could benefit them but harm a client? So those are all things that are really important to know about your funder.
Yeah,
Go ahead, Dave.
Yeah, I would agree with everything that Stuart said. I mean, I think for us, it really comes down to almost two words, which is trust and relationships. Building trusting relationships is really why we form Validity in the first place. And you really need to have a trusting relationship with your funder, because as we've mentioned before, it's going to be a small p, but partnership, tripartite relationship between the funder, the client, and the lawyers. And you have to be comfortable with the folks that you're getting into bed with in this long-term relationship. As Michael pointed out, is one of my mentors when I was a litigator at Gibson Dunn used to say that litigation or arbitration is really more like a basketball game than a soccer or a football match. There's going to be many points scored on both sides as the teams run up and down the court. There's going to be many ups and downs. There's not just going to be one or two goals in the game, and you have to be prepared to weather those ups and downs and be able to work with folks, through sometimes difficult times in a case to ultimately, get across the goal line. And so who you're working with and whether you can work with them is really important. And we find in both directions that the beginning of a relationship with a new client or new lawyers is always really important to gauging how you're going to get along down the road when things get difficult. And so when you're just even negotiating an NDA or getting initial information from a client or a lawyer or negotiating a term sheet is a good testing ground for how reasonable your counterparties, on both sides are going to be, and whether you think you're going to be able to get along with them when things, inevitably get a little bit tough down the road.
Sure. Yeah. And I think the earlier the better, because every step you take along the process binds you closer together. And you don't want to at the end of the due diligence, for example, you realize you hate the claimant or the funder or the client or the counsel or whatever. It's kind of very late then, and nobody wants to stop at that point. So you're in for a rocky, 2 to 6 years, depending on where you are.
Sure. And that's why I also think it's important that when claimants and law firms are looking at different funding opportunities, they don't just look at what is the best economic deal that I'm getting, because it is a long relationship. You do need your funder to be your partner to help deal with problems that come up down the road. And frankly, one of the great benefits of the funding community is because they're so populated by former practicing attorneys, they can oftentimes be helpful in terms of providing insight into the case from their own experience, either in their own private practice or from other cases that they're funding. This is not to say they're going to be controlling or dictating any result. They don't do that. But it's sort of the input and the additional sources of knowledge. And so these are all things that I would always want to try to encourage my clients who are claimants or law firms to sort of look beyond the mere numbers and try to think about how comfortable am I going to be with this in a year or two down the road? And will I be able to get meaningful, sort of substantive support from the funder when problems come up? And are they going to work with me in order to perhaps do a restructuring if we need to do that? How patient will they be in the process? So,
right, Michael, I think some of what you said was exactly to a question it looks like we got in the chat about whether funders can provide an objective view of the case, versus some lawyers who may not be as objective. And we do find that all the time that it can be helpful, especially our professionals, former trial lawyers, folks like Stuart at Statera, former litigators, have a lot of experience in evaluating matters, and it can really serve as a check for the client to have a funder who either believes in the case and is willing to put their sort of money where their mouth is, or doesn't believe in the case and finds some holes in the case that maybe lawyers who were just incentivized, to bring another case to get some dollars in the door were not as objective. And certainly the lawyers that we like to work with don't act that way, but there are, lawyers out there sometimes who will they're just happy to bring another case, and it doesn't necessarily matter if it's a good case or not. And so funders can serve as an objective check on the merits of the case. The knock against the industry when it first started was that funding helps bring about frivolous litigation, which is just in and of itself, I think, a frivolous argument when you look at our business model as non-recourse funding, and we're only getting a return if the case is successful. There's no reason for us to want to support frivolous cases. We're not in it to try to get a strike price out of a case. We need to get a healthy return, and so we can actually serve the opposite effect, more like a funnel, as Steve Sussman used to say, to filter out bad cases from being filed. If a client goes to several different funders who all turn them down, the client and the lawyer might take another look at their case and think about whether it really has as much value as they think it does.
Sure.
Yeah,
Sure.
I think something that is important in these kind of relationships, of course, is the trust that might exist between the funder and the counsel and client, and not because the funder will be in charge of driving the case, because that's not the case. Counsel is counsel, and of course the mandate to counsel it's from the client. But I believe, and what I have noticed in my experience is that funders may have incredible resources to help, and sometimes came up with incredible ideas. Sometimes in the due diligence process, we have identified risk, or we have identified advantages of the case that at the beginning we didn't. So I think this relationship and this trustful relationship is very useful.
Yeah, no, for sure. I mean, not to the risk of sort of, removing some of my business as a transactional attorney in this space, the documents are important, but the alignment in the economics and the transaction more broadly is even more important, because in the end of the day, you all will be on the same side of the table, fighting forward, against some common defendants here. And I think everyone wants to feel fundamentally that they've gotten a fair deal and that they're being treated fairly and respectfully during the pendency of the claims. And of course, ideally, when the outcome, it's a positive one and money starts getting dispersed, everybody feels good about where they were. And I think for most funders, a key measure of that is, do the claimants and law firms come back to them again? Do they feel that they've been respected and gotten a fair deal, and there's been an effective alignment of interests? Tim, you mentioned just in your comments previously about the importance of trying to sort of get an understanding of how this relationship is going to be very early on. And I guess sort of turning to you and to Maria Lucia together, what are sort of the lawyers and market expectations for funding in the international commercial arbitration context? What are the things like a firm like Aaron Fox or your colleagues? What's sort of most important for them in terms of just the market here, and particularly like in the DC market? In terms of funding. In terms of funding, what is what's kind of what are sort of the top three things that you're really most focused on as a law firm, but also of course on behalf of your clients? I mean, we're the differential and what we get in commercial arbitration that's not in ISDS is speed. We're looking at 24, 26 months out to have an award, and that's very important, and that's a big benefit of in our view anyway of commercial arbitration. We also expect it to be less expensive. It depends on the case, of course, but I'm just saying as a kind of a broad matter, we would expect it to be less expensive. And
the other aspect of this is we expect to be able to get the best arbitrators in the world. Just like ISDS seems to get the biggies all the time, but more and more you're getting the folks who are in ISDS serving as arbitrators in ICC arbitration, ABA, whatever it is, and so that helps in terms of your knowledge base because you're used to working with those folks in some capacity or other, and so it's the same kind of large group that keeps expanding, but you see similar names. So there's comfort in that in terms of what you expect in terms of maybe not the overall outcome, but certainly the way that they're going to behave themselves in there.
Sure. Now, turning the question around, I think to you, Dave and Stuart, what are the key characteristics that you expect your counterparty attorneys and claimants to demonstrate, both in terms of, obviously the merits of case, damages, accessibility, those kind of issues. So what are you primarily looking for as you're assessing lawyers and claimants and their claims?
Sure, I can start, Dave. I think the first one I would say is damages. It's been one of the most surprising, maybe I shouldn't say surprising, but one of the most striking things for me moving from the practicing side to the funding side is the emphasis on damages and having rigorous and realistic damages assessments as early as possible for a case. And when we get a funding memo, it's often the first section that we flip to is what do the damages look like here? And the reason for it is that we need to make sure whatever the financing amount sought is that it's supported by the damages, and that at the end of the day, the counterparty is going to be able to keep the vast majority of the expected recovery, and that there's going to be enough to support our return, and that there's going to be enough to support whatever the success fee is for the lawyers, if there is one. So I think that's really important. And we often see cases where there's not enough information early on in a case to know what those damages are going to be, and we'll work with clients through those situations. But it's tougher when you see the situation where someone says they were harmed, and if they hadn't been harmed, they would have been the next Apple or something like that. Those are hard damages to really get behind. You really want to see things that are grounded and realistic and rigorous. I think that ties into another piece, which is whether the lawyers have skin in the game, so to speak, whether they're on full contingency or partial contingency. And I come from Williams & Connolly, and on the spectrum of firms and taking risk, Williams & Connolly is on the far kind of right side of that in terms of not taking a lot of contingency matters. We were a much more traditional hourly firm, and it's not to say that a firm has to be willing to take a full contingency. But I do think we like to see if a firm's willing to at least put something at risk and put a little bit of an investment in. We just think that really helps align incentives over the course of the investment. And it's relative. Again, some firms are much more small c conservative and may not be able to do a full contingency fee or even a half, 50% off the rack rates. So we look at what they're able to do and what they normally do. If a firm that normally does cases on full contingency comes to us and says, hey, we're going to do this on a 30% discount, that might raise some red flags that they're not, as confident in that case as they are in other cases. And then the last thing I would mention is a budget, and having a really good, thoughtful budget. And I think in the legal services space, budgeting is more art than science. Given the unpredictable nature of litigation. I say this as a former lawyer, we're not necessarily the best, with numbers or at business. And so, budgeting doesn't necessarily come naturally. But I think trying to really put together a thoughtful budget that lays out what the costs are going to be by stage, and that goes through the hearing is really helpful in helping us assess, what's the real number that they need to take this across the finish line.
Yeah, to pick up on that, budgeting and duration are probably two of the hardest things to figure out at the outset. The budget is an art more than a science, and it's, lawyers have to be careful about it, because if you're too high and give yourself too much of a cushion, you may make it seem that the matter is too expensive to really justify the expenditure and not in line with the expected return. On the other hand, if you under budget, you may make it difficult to complete the exercise and create a situation of an expectation that it wasn't going to cost as much as it did, and then you have kind of some sore feelings down the road when it doesn't, when there needs to be more money put into the case, and then the client's in a difficult position, maybe if they don't have the money to add, or the lawyers can't add it, of asking the funder for more money, and the funder underwrote it on a certain, expectation, and so the funder might then ask for some concessions to add more money. And so getting the budget as right as you can at the outset is really, really important. I think, Stuart covered a lot of the things that we look for at the outset. Of course, we're looking at the merits and damages, collectability, who the lawyers are and what kind of alignment there is, and who our counterparty is I think one of the questions that Michael was getting at, and of course who the trier of fact is going to be, what the venue is. But as to the counterparty, what we're often looking for is a party that's going to be reasonable and commercial. If it's too much of an emotional exercise, that will scare us or scare many funders away. A counterparty that's going to be a good partner, alignment of interest with the counterparty and the counsel, and then really candor from the client and the lawyers as to really what they're looking for and what the strengths and weaknesses of their cases, and a reasonable damage assessment, as Stuart mentioned. I can't stress enough how important candor is, because generally, as we go through the exercise of kicking the tires carefully on these cases, we usually uncover what the main holes in the case will be if we haven't been told what they are at the outset. And if we're not told what they are at the outset, and we end up uncovering things that were obvious and that we weren't told, it really puts kind of a bad shine on the counterparty or the lawyers who were really only giving us the fluffy, positive side of it, and not the potential negatives. And that could ruin the trusting relationship at the outset.
Before we pivot to the next question, there was a question that came in from one of our attendees that maybe Dave and Stuart, you can speak to, and I'd be happy to add my sort of 2 cents as a fund formation attorney. But so the question is, could the panel please shed some light on the formation and structuring of the litigation arbitration fund? Are they different in structure than, for example, private equity funds?
I think funders are structured. If the question is going to how funders are structured, I think they're structured in all sorts of different ways. My particular company is set up as a company that we are majority owned by our primary capital provider, which is a private equity company called Towerbrook, based in the UK and New York. And all the investment professionals are invested in the company as well, with some friends and family. So that's our structure. There are plenty of funds. There are plenty of litigation finance companies set up as funds. And then how the actual investment agreement is structured between the funder and the client, there are also many different flavors of that.
Gotcha. Yeah, and I would add that again, there's all kind of flavors and variety here. I will oftentimes see newer funders or sort of first-time funders look to align themselves with an existing funder, so that, in fact, they're sort of seeded by an existing funder. So it's kind of funds to funds in a way, in that kind of structure. That oftentimes happens here, and then you try to leverage maybe a new niche that for the original sort of existing funder who may be investing into one of these new funds. They want to have a different kind of footprint. They want to maybe access a new kind of niche, maybe try out a different kind of financing and a different kind of structure. And of course, the good aspect of that is there's additional, capital that's coming into the new fund. It adds opportunity to grow you fairly quickly. On the other hand, as a new fund, you're also inheriting usually a fair amount of the practices and maybe even the control of the existing funder. So it's always a question of how much independence you have versus what you need. And I've seen funds structured as, again, LLCs, limited partnerships, sort of master feeder fund structures on the international side. There is a fair amount of interesting structuring that is in parallel with sort of the private equity and even some of the hedge fund structures here. I don't want to spend too much time on this, but one of the things I have seen occur, which is kind of interesting, is for certain type of projects that have a broader base, say it's a particular type of focus of litigation that maybe a law firm wants to develop. Sometimes it's hard for them to sort of be able to raise all the money they would like to raise initially. What I've seen and what I've helped a couple clients to do on the attorney side is I've helped them form sort of mini funds, kind of almost like a friends and family kind of fund that sort of creates the seed funding for this initiative. And that seed fund then serves as kind of the first loss capital tranche for a bigger financing that's done by maybe a more traditional funder. And I've seen a couple law firms leverage that very well, being able to, obviously that first money is at risk, but it also usually is attached to a significantly higher multiple or return. And this in turn has helped to kind of seed the firm, and then in turn beyond that, be able to bring in some larger pools of capital for whatever the enterprise is for the law firm.
Michael, before we move to the next question, I wanted to make like a small remark regarding the importance of the budget that David and Stuart were mentioning. And from the side of the counsel, of course, the client, well, for us, the budget, of course, is a function of a well-thought understanding of the facts of the case and the applicable procedural rules. So if the strategy that has been laid out by counsel in the due diligence memorandum presented to the funder is well set, well, then the budget should, of course, make sense. But of course, there is a caveat that the budget, of course, necessary should provide of some flexibility and contingencies, because it would be impossible to foresee every single thing in the budget presented to the funder.
So Tim, related to that, as an attorney, representing clients and trying to develop budgets for your clients, but also, of course, for the firm and for a funder, how do you go about doing that to make sure you're sort of in the right ballpark here? Because funders oftentimes will be very strict about these budgets, and they kind of really want to know that that their funding is going to cover the cost of this budget, and that's kind of what they're going to provide in terms of capital. So what's sort of the methodology and approach that you take?
Well, Michael, you get better with experience, like in many things. But basically, we lawyers are creatures of habit. We like precedent. And so the first thing you would do, and I think the first thing that I did, and this was in the State Department trying to budget an ISDS case, was to get a template from somebody. And then you have a basic template that includes all the phases that you anticipate in the proceeding, all of the expenses that you can think of that you will incur in the proceeding, travel costs for witnesses or for counsel or for the claimants, depending on where you are, the costs of the arbitration itself, for especially if it's an ICC arbitration, you've got to pay for that. So it's difficult when you think there might be a jurisdictional objection in there, might be bifurcation. So you're looking at different sort of scenarios as well for that. But I'm serious when I say that you get better with experience, because you build on those every case that you have, and we look at it and we say, okay, where did we make, where were we wrong about it? Where did we budget too high, too little? And so over the years, we have all of our budgets in a file, and we look to them, so we can get pretty close. But I will say that when you're required to put skin in the game, it's and if you're wrong on the budget, that's not a good place for lawyers to be, and so there is a lot of pressure to get that budget as right as you can. And so I would say that, the funding part of that is certainly disciplining on the lawyers who are making the budgets.
I think Tim has just hit on one of the exact reasons why a lot of funders are very interested in having the lawyers put skin in the game, because they're definitely more focused, on the budget, for one thing in that circumstance. And of course, it's a proxy for funders sometimes to know that the firm is saying it's the best case they've ever seen. But if they're not willing to put some of their own time and money at risk, if they are willing to put some of their own time and money at risk, it sort of shows that they really believe what they're saying. And so it's important to a lot of funders to see at least some risk taking by lawyers in cases that are being funded.
I think Tim also hits on one of David's points earlier about, just kind of candor. I think one of the things we look for in the budgeting process is when a law firm is really clear about what are their assumptions in the budget. Are they assuming, a combined jurisdictional and merits hearing? How many experts are they assuming, and things like that?
Yeah, that's right. That's right. And the more complex the case, obviously, the more complex the budget is for that reason. Yeah.
Sure.
And Michael, I would say we had a shared experience, with respect to a particular funder, that their philosophy was to overfund,
Right.
Make sure that the law firm was happy in a way, that there was going to be plenty of money there. Now, that has its own problems with it, which we can talk about a little later. But I guess there's a funder for everyone, I guess, is the point.
There is. I would say that situation probably, Tim, is more rare. Usually what I think the funders struggle with is trying to mitigate their downside risk, but of course have the optionality to put more money in particularly if the case is going well and merit. So, there's things like put structures and things that can either be very obvious ones or more indirect ones that sometimes come into the funding documents. Maria Lucia, just in addition to budget, how should claimants and their attorneys sort of populate the data rooms with information for the funder? What other information in addition to the budget should be in that data room?
Thank you, Michael. Well, the first thing I would like to say here is that, of course, is more than obvious that the better submission you have and present to the funder, well, your case will be more fundable. So taking that into account, I believe that there is a process that should be followed. And of course, there is certain information that must be presented to the funders to successfully obtain funding. And in the case of a strategy and how it works for us is that, of course, after analyzing the case with the client, we start preparing the due diligence memorandum, which I believe is the most important step or element in the founding process. And why I say that? I say it because it is fundamental for the third-party funding to decide whether they want to invest in your case or not. So how we structure that memorandum at Strategy? Well, at the beginning, what we do is that we include an executive summary with that short information about quantum, the facility requested, information, of course, about the parties, counsel, a short summary of the facts, analysis on jurisdiction, analysis of enforcement, and why we believe this executive summary at the beginning of the due diligence memorandum is important. And this is because this gives to the funder a general overview of the case without needing to analyze the case and to decide whether it's worth it or not to invest time in this case. So after that executive summary, what we do in our due diligence memorandum, of course, is that we include a very detailed chronology of the facts. And of course, in this chronology, we make reference to all the evidence that is fundamental for the case, because it makes no sense to present a case that in paper looks strong in the merits without including the evidence that actually support it. So for answer part of your question, what is important to include in the data room, apart from the due diligence memorandum, of course, is all the documentation that supports our case. I mean, when we prepared this due diligence memorandum, is that we were preparing the request of arbitration or the claim for the investment or commercial tribunal. Also, what we include after the facts of the case is, of course, a very good description of the quantum of the case. We do a very good job at a strategy to determine the calculations and the expected damages in each particular case that we manage, as well as the budget requested, as Stewart and David were discussing. We also include a brief description of the parties, and of course, at the end, we include a very long description about the legal claim, which might include the analysis of jurisdiction, analysis of the duration of the case, and then a good analysis on marriage, which of course will include the claims, the defenses, recommendations and conclusions, and of course an analysis of all the advantages and risks that we find in the case, because we want to come full transparent to the funder, and of course also remark the risks that we see in our case. So after that, we of course prepare the data room with all this information that I'm mentioning, including the budget, very good descriptions, and all the evidence that of course we are mentioning in our due diligence memorandum.
Great. Thank you, Marisa. That was very comprehensive. Before we turn to our last topic, there's a question that came in from one of our attendees who's in Egypt. So welcome to all of you from around the world. And the question really is, what happens when in international arbitration, a funded party loses his case or her case or its case? And I think, sort of fundamentally, we have to understand this industry is premised around the idea that litigation funding is effectively non-recourse finance. And that's the risk. And that's why sort of the cost of this financing is usually seen to be higher than other type of financing, such as from ordinary commercial banks. The funder is really funding the fact that there's going to be success in this case on the merits, and there's going to be damages, and there's going to be damages that are collectible in a sufficient amount to repay the invested capital plus a healthy return, make sure the attorneys are fully paid, and still enough money in that damage award to make it have been a meaningful effort for the claimants. So, generally these are all structured as non-recourse. There are some limited exceptions to that, such as fraud or intentional misrepresentation or diversion of the funder capital that may make it more recourse, but it's effectively a non-recourse funding asset class. I don't know if any other participants want to add something to that. Well, let's turn then to our last. I think we just have a few more minutes here before we have to wrap up. So I think the question now, we've explored a lot of things about the market drivers among the funders, the claimants, and the lawyers. We've also sort of, talked about, some of the sort of more structural aspects and how funders and claimants can enhance their likelihood of being financed by being more complete in terms of the information that's provided, especially, around budgets and sort of clarity and completeness with the funders. Now, but how do claimants and attorneys and funders actually get together? I mean, as we've been discussing here, there's a really a very broad range of funders. In your experiences as funders, and I'll direct this to Dave and to Stewart to start with, where are most of your cases coming from? How do they get to you?
Yeah, I mean, I think most of our cases, and certainly our best investments, generally come through trusted law firm or legal industry related contacts who we've built trusting relationships with over the past decade or so that many of our professionals have been in the business. And so lawyers have a client who has a great case, but they don't want to or can't afford to pay an hourly rate. The lawyers, let's say it's some great firm like Tim's, don't want to take the case on a full contingency, and so they'll look for a funding partner to come in and bridge that gap and take part of the risk of the funding. That's the most traditional way cases come to us. Of course, folks like Statera and us have built our brands over the past bunch of years, so we get folks that come to us directly. sort of reaching out through the website or calling us directly and we haven't known. And sometimes there could be great cases there, but you have to sort of weed through those a lot more than when someone who knows you and what you're looking for comes to you with an opportunity.
Sure. And Marie-Lucie, and for you, Tim, if you're representing your clients looking for funding, I know, Marie-Lucie, you mentioned a database that you all keep, but in addition to that, how do you go about, helping the clients to find this best fit? Is it also kind of through referral networks or just general market knowledge? How do you actually go about getting the matchmaking done?
In my case, of course, we review the main characteristics of the case and its key factors. So we start by answering questions like, what is the industry related to our case? What is the quantum? Which is the seat of the arbitration? It is a domestic or an international arbitration? And when we answer all these questions, and of course we use our database, we can determine who is well suited in order to help us to fund our client case.
And I would say that, it's like a circle within a circle, is that we first go to the people that we know and trust. And, that is validity with Dave and Will and Stuart at Statera. And of course, Michael's we call you too much, Michael. But because we know we're going to get a sort of straight answer on it, and we have the relationship, so we trust them. I feel like hopefully they trust us. But that's, and then if that doesn't work, right, and we have a particular client now with a particular case, and our trusted people have said, no, this is not ours for one reason or another, and all good reasons that we understand and respect. But then we have to go wider, and then it becomes more of a crapshoot in a sense. But it's always referrals, like it's Dave or Michael or Stuart, will tell us, okay, this is not ours, but it might be somebody else, and then frankly, part of the reason I'm very happy to be here today is that coming to these kinds of events, you get to see people who are in the industry, and that gives you a sense of the person, and you'll follow up afterwards or whatever. But it's not rocket science, but it is about relationships fundamentally.
Yeah, I'll agree fully with that, Tim. This is a relationship-driven business. And I just always would encourage, claimants and law firms, much like the funder's going to do due diligence on the lawyers and the claims and the claimants, you need to do your due diligence on the funders as well, to make sure they are that right fit. Do they even, finance international arbitration cases, to things down to those more intangible aspects of how hard were they to get a deal done? How was it working with them down the road when the cases was being developed? And there are through brokers, there also are through service providers, such as those who transactional work in this space, who, we're always obviously happy to sort of talk to parties and attorneys and claimants and maybe help direct them into the right place with the funder. Depending again, as Marie-Lucie was saying, what is their primary characteristics? What are they really needing to try to have in terms of funding here? We are almost out of time. I know there were a couple of questions here that came in. There's a question about small funding matters. They want us to elaborate on some of our experience in funding smaller claims. Stuart, do you want to? I know that's really been an important part of the Statera, thesis. Can you want to take that one?
Yeah, happy to. Thanks, Mike. You're right. That part of our thesis is that there was a large segment of the litigation and international arbitration market that wasn't being served by some really more kind of first generation funders because they were focused on much larger cases. So we've successfully funded arbitrations, that required financing in the six figures And, we projected the resolution value to be in the mid seven figures. I think it's really just a question of making sure the damages support what the financing is, and that otherwise everything else lines up, that you've got good lawyers, you've got a strong counterparty, and then you've also got a respondent that's going to be able to pay the bill at the end of the day. And I think we've kind of alluded to this throughout this session. One of the appealing characteristics of international commercial arbitration is that you're generally dealing with pretty sophisticated companies that are going to have enough resources in most cases to pay a judgment or pay an award. That's obviously part of the diligence. But, so a short answer is we definitely make it work and are always excited to see those types of cases and work with parties on them.
There's another question that came in that I think is an important distinction here, and that is a question: what are the most important differences between commercial and investment arbitration from the perspective of third-party financing, in particular with respect to selection of cases? I think maybe the question has to do with sort of international commercial arbitration versus sort of investor-state arbitration. Anybody want to try to tackle that one?
I could take a first crack at it. I mean, I think one of the biggest differences that we look at, and that makes us sometimes a little bit shy about investor states arbitrations as compared to commercial arbitrations, is just the duration. The length of time it takes to get from beginning to end is pretty lengthy as compared to a domestic litigation or a commercial arbitration. And in addition to the actual length of time of the proceedings, you will then also often have collectability and enforcement follow-on proceedings. And so you can be looking at somewhere between a 5 and 8 or 10-year exercise. Most funders are very conscious of their cost of capital and their return and their IRR. And the longer it takes to get a return back, the more difficult it is to structure a return that is beneficial to everyone in the investment. And so it makes it a little bit harder if they're going to last that long.
Understood.
Can I just add one thing, Michael? Just
sure.
I said earlier that you're seeing the same arbitrators in both international commercial and investor state. I believe that is true. But at the same time, I think our view is that if we have a commercial case, we want to make sure we have an arbitrator that understands commercial issues, and so we would have to take out those people who are in ISDS and focus really on public international law issues. To focus on the people who do know commercial work.
Sure. We had one other question here, which Maria Lucia, you already answered through the chat, but maybe you can just share your answer more broadly here. But Alan asked, how much due diligence is done on whether the other party to the arbitration can pay a large award? How do you do that?
Thank you, Michael. Yes, as I was mentioning, Alan, this is an issue, of course, on enforcement and collectability. And what we do as counsel is that, of course, we analyze whether the opposing party, which depending on the type of case will be a private company, of course, a sovereign state, it has assets to pay in the case. And of course, we have developed a bit of experience in asset tracing, but what we do is also that we contact closest people that we have in our network in order to do a wider analysis on the assets that the respondent may have.
Well, look, it's now at 5:15, so I think our panel time is actually expired. Just a huge note of thanks again to Dave Kirstein from Validity, Maria Lucia Casas from Xstrategy, Tim Theory from Aaron Fox, and Stuart Akerley from Statera. I really enjoy these guys. I learn something new every time, and couldn't have asked for more knowledgeable set of panelists today. I hope that all the attendees have found this helpful. I think probably speaking for all of us, we're always happy to field additional questions you may have, and obviously happy to continue the conversation with all of you. So thank you very much again. And again, thank you to Jose Antonio, and again, Maria Lucia, to you and to Milena for all your organizational efforts, not only for our panel, but for the whole conference.
Well, thanks a lot, Michael. Thanks, everyone.
Thank you.
Thank you.
Thank you so much. Really, thank you so much, Michael, for that dynamic role of moderator. And kudos to, as I see you, to David, Stuart, Maria Lucia, and Tim. It was an incredibly knowledgeable exercise, and I learned a lot as well. Hopefully, after this session, everyone will find their match. So there's still opportunity to find your match. We're going to go into the breakout rooms in just a few seconds. For those of you who have not done a breakout room session, make sure that you do hit accept when you're invited into any breakout room. And the dynamics of the breakout room will be there, and you are the stars. The panelists are the stars of the session, so people may want to talk to you and ask you questions, perhaps completely unrelated to third-party funding and arbitration, but perhaps somehow related. So enjoy your session. Thank you so much, and have a lovely evening. Bye-bye.
Thank you.
Thank you all again.
Thank you.
Bye-bye.